Hashtag how immigration law works in America. Hashtag legal brief. Full narration script. Every single day, approximately 2,200 people become lawful permanent residents of the United States. Every day, immigration courts process thousands of cases. Every day, someone's entire future hangs in the balance of a legal system so complex that even experienced attorneys dedicate entire careers to understanding just one corner of it. Immigration law in America is not a single law. It is not a simple process. It is a layered, often contradictory, historically evolving web of statutes, regulations, court decisions, and executive policies that governs who gets to enter this country, who gets to stay, and under what conditions. Today, we are breaking it all down, from the foundational history to the visa categories, from green cards to citizenship, from deportation to asylum. By the end of this video, you will understand how American immigration law actually works. Hashtag background. Where did American immigration law come from? To understand today's system, you have to understand its origins. For the first 100 years of American history, there was essentially no federal immigration law at all. States regulated their own borders, and immigration was largely open. That changed dramatically in 1875 with the Page Act, which was the first federal restriction on immigration. Then came the Chinese Exclusion Act of 1882, the first law to explicitly ban an entire nationality from immigrating. These early laws set a troubling precedent that immigration could be restricted based on race, national origin, and perceived social value. The modern foundation of American immigration law was built in 1952 with the Immigration and Nationality Act, commonly called the INA. This massive piece of legislation consolidated previous immigration laws into one comprehensive statute and created much of the framework still in use today. Then, in 1965, the Hart-Celler Act dramatically reshaped immigration by eliminating the national origin quota system that had favored Western European immigrants. This single law fundamentally changed the demographic composition of American immigration, opening doors to people from Asia, Africa, Latin America, and the Middle East in far greater numbers than ever before. Today, the INA as amended remains the core legal text. It is found in Title VIII of the United States Code. It is administered primarily by three agencies: U.S. Citizenship and Immigration Services, known as USCIS, which handles applications and benefits; Immigration and Customs Enforcement, known as ICE, which handles enforcement and removal; and Customs and Border Protection, known as CBP, which manages ports of entry and border security. Understanding which agency does what is step one in understanding how the system actually functions. Hashtag main content. The visa system explained. At the heart of American immigration law is the visa. A visa is essentially government permission to enter the United States for a specific purpose. There are two broad categories: non-immigrant visas and immigrant visas. Non-immigrant visas are temporary. They allow someone to come to the United States for a defined purpose and a defined period of time. The most well-known is the B-2 tourist visa, which allows visitors to stay for up to 6 months. But there are dozens of other categories. The F-1 visa covers international students. The H-1B visa is for skilled workers in specialty occupations, think software engineers, doctors, and architects. The J-1 covers exchange visitors. The L-1 covers intra-company transferees. The O-1 is for individuals with extraordinary ability in their field. Each of these visa categories comes with its own requirements, restrictions, and renewal processes. The H-1B visa deserves special attention because it is one of the most contested visa categories in America. Only 85,000 H-1B visas are issued per year under the cap, including 20,000 reserved for people with U.S. advanced degrees. In recent years, hundreds of thousands of applications have been submitted for that limited pool, requiring a random lottery selection process. This means qualified, sponsored workers are sometimes rejected simply due to chance, a reality that shapes how American companies recruit globally. Immigrant visas, on the other hand, are pathways to permanent residence. These are divided into family-based categories and employment-based categories, with additional pathways for refugees, asylees, and the diversity visa lottery program. Hashtag deep dive. Pathways to permanent residence. The green card, officially known as a lawful permanent resident card, is the golden ticket in American immigration law. It grants the holder the right to live and work permanently in the United States. There are approximately 13.9 million green card holders in America today. But how does someone actually obtain one? Family-based immigration accounts for the largest share of green cards issued annually. The system is divided into two tiers. The first tier covers immediate relatives of U.S. citizens, spouses, unmarried children under 21, and parents. This category has no annual numerical cap, meaning there is no waiting list based purely on numbers. The second tier covers other family relationships, adult children, siblings, and the spouses and children of green card holders. These categories do have annual caps, and they have waiting lists that can stretch years or even decades. Filipino siblings of U.S. citizens, for example, have historically faced wait times exceeding 20 years. Employment-based green cards are divided into 5 preference categories, EB1 through EB5. EB1 covers priority workers, people with extraordinary ability, outstanding professors and researchers, and multinational executives. EB2 covers professionals with advanced degrees or exceptional ability. EB3 covers skilled workers and professionals. EB4 covers special immigrants, including religious workers. EB5 covers immigrant investors who invest at least $1.05 million or $800,000 in targeted employment areas and create at least 10 full-time jobs. Each employment-based category has an annual numerical limit, and these limits are further divided by country of birth. This country-based cap creates extraordinarily long wait times for immigrants born in high-demand countries. Immigrants born in India applying under the EB3 category currently face estimated wait times exceeding 100 years. That is not a typo. This is a structural reality of the system that Congress has not yet resolved. Hashtag deep dive continued. Asylum, refugees, and humanitarian protections beyond family and employment pathways. American immigration law provides protections for people fleeing persecution. The two primary mechanisms are refugee status and asylum. Refugees are people who apply for protection while still outside the United States. The U.S. Refugee Admissions Program sets an annual ceiling for how many refugees can be admitted. In fiscal year 2023, that ceiling was set at 125,000, though actual admissions have historically fallen short of the ceiling. Refugees must be referred through the United Nations High Commissioner for Refugees or a U.S. embassy and must undergo extensive vetting before arrival. Asylum is for people already in the United States or arriving at a port of entry who are seeking protection. To qualify for asylum, an individual must demonstrate a well-founded fear of persecution based on one of 5 protected grounds: race, religion, nationality, political opinion, or membership in a particular social group. This last category, particular social group, has been heavily litigated, with courts debating whether domestic violence survivors, gang violence victims, and LGBTQ individuals qualify. The outcomes have varied significantly depending on the political administration in power, highlighting how immigration law can shift dramatically through executive policy without Congress passing new legislation. Withholding of removal and protection under the Convention Against Torture are additional humanitarian protections that provide relief even to individuals who may not qualify for asylum. These are distinct legal standards with different burdens of proof and different levels of protection. Hashtag analysis, enforcement, deportation, and immigration court. Now let's talk about the enforcement side. When someone is found to be in violation of immigration law, whether through overstaying a visa, entering without authorization, or committing certain crimes, they become subject to removal proceedings, which is the legal term for deportation. Immigration courts are not part of the regular federal court system. They fall under the Executive Office for Immigration Review, which is a division of the Department of Justice. This means immigration judges are technically employees of the executive branch, not independent Article 3 judges. This distinction has enormous practical consequences for due process. As of recent reporting, the immigration court backlog has exceeded 3 million pending cases. Many individuals wait years before their cases are heard.